Just need to print it once?
Should be two.
Right, just once each, okay.
All right, we're on the record now in People versus Christopher Crisp. We got 4 files set for hearing today. We have Three, six, five, 1, 2. So, all of these files are set for sentencing today. Mr. Chris, you had a chance to go through sentence reports that we prepared.
I did, but I don't really understand it.
I don't understand.
I mean, I don't know what it means between the different ratios or what it said. I just know it said just points for me for getting in trouble and that I was on probation. That's really, I think I really understood it.
You might not understand the scoring.
Okay. Do you want to have a chance to talk to Mr. Brown further before we go forward?
Okay, I trust you.
Okay. All right. Have you had a chance to go through them with him? No.
He sent them to me in an email and I went over them.
Okay. Do you want to have a chance to talk to him about those here today before we go forward?
Okay.
You remember talking to me about? That's what the judge is asking.
Yes, sir. I'm good.
Okay. Did you talk to him or not?
Yeah, we talked over the phone about
You
it.
did. Okay. All right. And you're saying you don't need to talk to him any further before we go forward with sentencing today?
I think so.
Okay. Mr. Brown, are there any additions, deletions, or corrections to either the violation report on those 2 files or the PSI as to the retail fraud or the drug charge?
No, Your Honor, and no challenges to the score.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Challenges to the scoring?
No, Your Honor.
Here, if I could briefly approach.
Sure.
I just got some letters printed out today that were just brought in.
The record on the front showed those to me. I have no objection.
And for the record, I did receive both of these prior to the hearing today. I did have a chance to review these prior to the hearing. And then I also got a David Durst, on behalf of Mr. Crisp, that I had a chance to review as well. Mr. Rolla, did you say that you had any additions, deletions, or corrections?
No, we do not, Judge. Thank you.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Do you want me to address the probation violation separate or whatever the court preference is?
I think if you want to allocate on the violations first and then on the newer files,
Very good. That's
I intend to just take all the statements and sentence as all.
I figured that's what the court would do. It's just if you have a preference, that's how I do it.
Sure.
Because of course, as it turns out, some of the violations are as a result of the subsequent files that Mr. Chris was now facing sentencing on. In dealing with the violations, that's all I'm going to address it as far as that. I reviewed those. I understand what the basis is, and I see the recommendations on there. I don't take issue with that. As to the 2 more recent files, specifically the furnishing contraband as a habitual second, file number 2365.2. Oddly enough, or ironically enough, depending on how the court chooses to address it, the method by which the Suboxone was taken into the jail was being shipped in a book called Chaos. I say that ironically because then it effectively, ironically created chaos at the jail, not only to the extent of the concern that you have for having controlled substances brought into a jail, creating the danger that was described in the pre-sentence investigative report, but in this particular case, as a direct result of that happening, the jail then canceled the program the library, our local county library had with the prisoners book exchange at the jail. That no longer was in existence. So it wasn't mentioned in the PSI. I just bring that to the court's attention as a, either as an unintended consequence or as a fact, a consequence of the defendant's actions.
So I just want to make sure I'm clear. So there used to be a program where the library would allow books to be brought in.
Oh, in fact, yes, the second person in charge of the library would come in either every week or every other week. That's Miss Audrey Fournier. She happens to be a friend of my daughter since about second grade, so I've known Audrey for a very long time. In any case, she came to me and she asked me if there was anything I could do to get the book program reinstated, because every other week she'd bring a cart of books and they would swap them with the ones that they had in the jail that the prisoners could read and study on and do a whole bunch of things. But after this offense occurred, the jail canceled that program.
Okay. All right. Thank you. I just wanted clarification.
Sure. And as to the situation with the retail fraud, again, we have a circumstance where it's another example of, unfortunately, a very long history of situations where in a number of these matters, Mr. Crisp got involved in the same matters with his, well, as indicated in the earlier cases, for which he's now on a violation for, with his former girlfriend, now his wife, Jacqueline. She, of course, was involved in the controlled substance situation, and she's a co-defendant in the retail fraud situation. So it's been going on since at least 2021. I guess my point is simply this: the two of them, and again, I don't want to have Mr. Crisp held responsible for Jacqueline's activities, nor Jacqueline held responsible for Mr. Crisp's activities. But the reality of the situation is these matters, they're very often co-defendants on. And again, I don't know how, quite frankly, the court can address that. But there is a recommendation now because of most recent actions for the Department of Corrections. And unfortunately, the defendant, by his actions, has presented himself to create a risk for society. So I leave that to the court's discretion in regards to imposition of sentence. Thank you, Your Honor.
Thank you, Mr. Brown. Excuse me, Mr. Brown.
Your Honor, first, and this was news to me about the book program, but the court is well aware there has been contraband taken into the jail on multiple occasions by multiple different people. I would have to assume that maybe somebody tried to get him in through a book in the past. I don't think that can necessarily be attributed to Mr. Crisp in this particular situation. He does have a very lengthy criminal history, the vast majority of which involves drugs and substance abuse, and he's very well aware of that. He is still at the age, I believe, that rehabilitation is very possible. He has bettered his life. He is currently employed full-time. He has not messed up since he has been out on bond, to my knowledge. He is currently enrolled in Harbor Hall. He has been in counseling. His support is here, someone from Harbor Hall, and I believe his counselor as well. They speak very, very highly of him. He is very committed. There's been some issues with him, the people that he may have associated with. This court's well aware of the impact that substances have on people, the way that it makes them think. But he has been clean from substances for a very, very long time now. And by all accounts, has really turned his life around. We see this, and the court sees this a lot. But there does come an age, and I believe that Mr. Crisp is at that age, that he does not want to spend his life in prison and doesn't want to spend his life surrounded by substances or doing actions that substances ultimately lead to many times as well. So I would really ask the court to focus when sentencing here, focus on the rehabilitative potential in Mr. Crisp. Notwithstanding his very long record, this is perhaps the longest he has ever gone in a program, the highest praise he's ever received from people in that program that are firsthand witnesses to his progress and what he has done with his life. Some of these people that are in the program were in the same situation as Mr. Crisp, and now they are actually leaders at Harbor Hall because they have that firsthand experience of what addiction and things like that can do to a person, but they also have the firsthand experience of a person's potential to rehabilitate when they really put their mind to it. And Mr. Crisp has been involved in things that are beneficial to the community. Employment is very beneficial to the community. The thing that I am concerned with, and I understand as well as does Chris, there has to be punishment involved with wrongdoing. But I believe in the long term, the goal should be to try to rehabilitate them as much as possible. And I think that's what he's getting through his programs and his therapy. The one thing that I don't want to see for him is a period of incarceration that is going to essentially make him start over when he gets out. The court has seen, I'm sure, many times that people are doing well, but they get incarcerated, they lose their home, they lose their job, they lose all of their support systems. And when they get back out, they feel lost. And unfortunately, it is a vicious, vicious cycle that keeps going on. And so I would ask the court to take those things into consideration when fashioning a sentence hearing.
Great, thank you. Mr. Chris, anything that you wanted to say?
Your Honor, I take full responsibility. I was in drug addiction at the time. I've been on drugs since I was 14 years old. I finally come to the realization last year that I couldn't do it anymore. I've lost everything. I've lost everything I've ever worked for. And since I've been at Bear River and Harbor Hall, I've been able to regain employment, full-time employment. I live in a sober living house. They're wanting to continue my treatment. And I apologize for having to come before you again. I've done wrong. You've got to do what you've got to do. But I do own up to my wrongs.
I did read through the report. I'm familiar with what happened in the case involving the stocks on the jail. And obviously, the court presided over your trial retail fraud case. And, you know, I struggled a lot with how to address your files because the guidelines do allow for prison times, obviously, up to 46 months, so almost 4 years in prison at the top end of the one files guidelines. The bottom end allows for community sanction. So there's a wide range available to the court in terms of sentencing to still be within the guidelines.
Sure.
I think there are a lot of things about your cases that are negative factors that would tend towards a prison sentence. You know, bringing drugs into the jail is a dangerous thing. I had a number of cases where people died from using illicit drugs brought into the jail. The unfortunate thing Mr. Rolla just indicated, you know, you've got a bunch of people that are down there now that don't have a resource available to them in terms of books that they would have otherwise had, but for your conduct in this case. The retail fraud case, you know, I don't believe that at all. Like, I don't believe that you didn't know what was going on at all. I heard the evidence, I saw the videos. I think you definitely knew what was happening. And so, you know, claiming you didn't is a little bit disingenuous at the generous end of that. I think you tend to make excuses for stuff. I think you try to pass off some of your conduct on other people or other circumstances. Those are all the things that I see are negative that I think would warrant a prison sentence. But there also are positives, and you know, I don't necessarily believe everything that you say.
Yes, sir. I understand that.
Because of my past experience with you and
Yes,
my
sir.
experience seeing what's happened in your cases. But I'm getting this from people from Harbor Hall who I have no reason not to believe. And the indications I have from them are that you're doing well, that you're complying with the programs.
Sure.
And that those people are seeing improvements and have reason to think that you're going to continue on that path and that you're starting to get a hold of this problem. And I say all of those things to say that I am going to give you an opportunity to continue with that, only because of what I've gotten from them, information that I've gotten from them. And I'm going to place you on a period of probation, which isn't recommended, and which I'm somewhat hesitant to do.
Understand.
But I also think it's appropriate, because you're doing well now, to give you an opportunity to continue on that path. I will tell you in no uncertain terms that if it doesn't work out, I'm not going to buy any excuses about why it hasn't worked out.
Sure.
And the court is going to consider, prison time if you violate your probation here.
Sure.
So I'm giving you an opportunity with the understanding that if you don't take advantage of it, I'm done. That's it.
Sure.
You will have burned the last bridge that you have
Sure.
to keep you from prison on these cases. So I'm going to, again, as to file number, well, first of all, dealing with probation violations, I agree with the recommendations there. Both of those files discharge you unsuccessfully, credit for time served, and to preserve any outstanding fines and costs. And that's on file 216235, 216237.
I've been paying all those, Your Honor.
Okay, good. You're going to need to continue to do that.
Yes, sir.
As to file number 236512, the court is going to place you on probation for a period of 24 months. Court's going to adopt as the conditions of your probation all the terms and conditions of your previous files. On that file, the court is going to impose 5 months in the Otsego County Jail. You have credit for 9 days served on that file. The court's going to hold that time in abeyance to be served at the discretion of the court. So if you do violate your probation, the court can impose any or all of that jail time immediately, whether or not you're found guilty of a probation violation or not.
Sure.
And then, of course, as I said, if you are found guilty of a probation violation, you can expect a fairly significant sentence.
Sure.
On that file, a crime victim's assessment of $130, attorney fees of $350, court costs of $325, $68 state cost. The court would consider community service in lieu of payment of attorney fees and court costs as to that file. As to file 236585, court also sentences you to 24 months of probation, again pursuant to all the same terms and conditions. As to that file, 9 months in the Otsego County Jail with credit for 2 days served. Again, that time to be held in abeyance to be served at the discretion of the court. Crime victim's assessment of $130 and a $68 state cost. You do have the ability to seek an appeal of the sentence in 6512 because the sentence in 6585 is pursuant to a jury verdict. You do have the right to appeal that one. Mr. Brown is going to provide you with those papers, and you just need you to acknowledge receipt of those.
Judge, one other issue, since the offense in regards to file number 236512 is due to jail at the time when Mr. Chris was incarcerated out of the matter, years mandatory consecutive sentencing. Does this court choose to address that on the record?
Yeah, so to the extent that any of that jail time is required to be served, the court will require it to be served consecutively as required by statute.
All right, thank you, Judge.
And Mr. Brunical, is Ms. Davis going to be the supervising agent? She would. Okay, so I'm assuming she'll contact Mr. Chris to go through the terms of probation. Okay, so Mr. Chris, Ms. Davis is going to be contacting you to make sure that you follow up with that.
Yes, sir.
Get that. Mr. Rolla, anything else that we need to address for the record?
No, I don't believe so. Thank you, Your Honor.
Mr. Brown?
Just for the record, he has acknowledged his appellate rights. I tendered those acknowledgements to the court.
All right, good luck to you going forward, Mr. Chris.
Thank you, sir.
Oh, I didn't even know it was cracked.
We have Ms. Walter present. Ms. Walter, if you want to come forward, People versus Veronica Walter, case number 246690.
Record show, I apologize.
Larry Brown, Ms. Walter.
This is the date and time set for sentencing in this matter. Ms. Walter, record should reflect Ms. Walter's present here in the courtroom today. You have a chance to go through the pre-sentence report and talk to Mr. Brown.
Yes.
Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and no challenges to the scoring.
Mr. Rowland, do the people have any additions, deletions, or corrections?
I don't believe it. I want you to prove it. The only addition, Judge, would have been that the firearm in question is mandatory confiscation and condemnation for 752.
Any challenges to the scoring?
No, Judge.
Anything on behalf of the people for Alex?
Judge, it's a situation where it's a first felony situation, there's a recommendation of 18 months, 90 days held in advance with fines, costs, and the other penalties. Again, people don't have any specific objections to that. Obviously, you know, this firearm, Ms. Walter, in addition to losing the firearm, is going to lose any ability she has for possessing a firearm, any ability to get a concealed weapons license, etc. Thank you, Judge.
Mr. Brown?
Your Honor, I would agree with the recommendation. Having this on the record does have its own penalties. She is going to be on probation, knowing that there is time hanging over her head if she does anything to violate that probation. While this is a firearms offense, it was a lawfully owned firearm by Ms. Walter. It was carrying it concealed in a vehicle. So this wasn't like a stolen weapon or untraceable weapon or anything like that. This was a concealed carry violation, which she got in the car and improperly dealt with that firearm. So there was no violence or any indication that she intended to use it for any nefarious purpose. So I would ask the court to take those into consideration and follow the recommendation.
Ms. Walter, anything that you wanted to say?
No.
I read through the report. I'm familiar with the circumstances that bring you before the court today, as well as the information about your background and your history and so forth. Looking at all of that, I do think the recommendation is appropriate here. I think a period of probation to monitor your compliance with all those conditions, as well as to monitor that you don't have any further interactions with the criminal justice system, I think is appropriate. I think it's also appropriate to hold the jail time in abeyance. There aren't any aggravating factors here that I think would require upfront jail. I think holding that in abeyance, and obviously if you successfully complete your probation, you would never have to serve that time. And I think it does provide a good motivating factor to keep you in compliance as well. So the court is going to adopt that recommendation and sentence you to probation for a period of 18 months. The court is going to adopt as the conditions of that probation all the terms and conditions in the report. Ms. Davis, it looks like will be your supervising agent. She'll go through all those conditions with you, but it's important to understand what you can and can't do with the next 18 months. The court is going to sentence you to 90 days in the Otsego County Jail with credit for 2 days served. The court is going to hold that time in advance. The court will impose a crime victims assessment of $130, attorney fees of $350, court costs of $325, DNA testing fee of $60, supervision fee of $30 per month while you're on probation, $68 state cost, and mandatory forfeiture of the weapon pursuant to statute. You do have the ability to seek an appeal of this sentence. Mr. Brown is going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with it.
She has acknowledged those rights, Your Honor. I'm tendering that to the court.
Mr. Rolla, anything further in this case?
Yeah, thank you.
Mr. Brown.
No, Your Honor, thank you.
So, Ms. Walter, Ms. Davis will be in touch with you. Make sure that you follow up with that call when you get that, and good luck to you going forward.
Thank you.
Our next hearing set for 2:15 will be in recess.
on the record in People versus Corey, Mexico, case number 236537. Record should reflect Mr. Mexico's present here in the courtroom today. If I could have both counsel put your appearances on.
Claire Brown on behalf of Mr. Mexico.
All right, this is the date and time set for in this matter. And Mr. Mexico, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that? And Mr. Brown, I know you have a scoring challenge, but before we get to that, are there any additions, deletions, or corrections?
I do have a couple here, Your Honor. On offense number 9 of 9, which is this one, it says added count 5, possession of cocaine. It's actually a possession of fentanyl.
Possession with intent to deliver fentanyl, correct, Judge?
Okay, so the court will order that be corrected at entry 9 of 9. No,
So I do a possession of fentanyl.
Possession.
yeah,
Although I said possession with intent.
no, that would,
That was the original charge, Your Honor.
right, not the charge that was applied.
Correct.
So that
We're
should read-
striking cocaine and putting in fentanyl.
Correct.
All right,
Yes, not
Just so-
possession.
just so
possession.
we're all clear.
Okay. Any other corrections?
One more here under the family section. He would like added that his mother did remarry to a gentleman named Ken Foster, who is now his stepfather. And he has a stepsister, Cassandra Foster.
Any objection to those additions?
No, Judge.
Okay, the court will be order that that section be amended to reflect that information.
The other ones, Your Honor, I think I would use an allocution. They are, I don't know if I should add them or submit a correction. He's stating, there's a part in here under substance abuse where they're stating that he never sought treatment on his own, which he disagrees with. I don't know if that's something for allocution or if that would be something that would be amended or added.
Okay, I mean, Mr. Mexico, have you sought substance abuse treatment on your own?
Yes, I was doing a Suboxone treatment program.
What?
Suboxone.
Okay. When were you doing that?
I was doing that the entire time I was on bond.
Right, I don't have a problem adding that information. So while you're on bond in this case,
Yeah, I'd go meet with a counselor every week. And she had me on Suboxone.
which service were you using?
Once in behavioral health.
Okay, so the court will order that the report reflect while I was on bond for this case, Mr. Mexico would participate in outpatient Suboxone treatment. Anything else, Mr. Brown?
Possession with intent to deliver.
He was questioning about a possession with intent to deliver rather than a delivery charge, even though they're the same statute. I don't think that is going to make a difference on here. I think the difference is he pled to a possession with intent rather than an actual delivery.
Yeah, I mean, that's something that you can allocate about the different, the distinction between that in terms of what you view your actions were, Mr. Mexico. But for purposes of the statute, conduct is the same either way. So I'm not going to change the report on that, but I'm certainly willing to take into account actual differences in terms of your participation.
There was one other under the description of the offense narrative. The report states that the search produced 0.8 grams of fentanyl and 6 paper bindles of fentanyl.
Okay.
And he is stating that the 6 bindles of fentanyl, that was the 0.8 grams. They're not separate.
Judge, I think that language can work. We should. I don't know if that's correct or not. I should probably verify.
Okay, yeah, I mean, we can take a look and see if and is the incorrect word there.
Judge, I'm reading directly from the police report. I'll read it verbatim to the court. This is under further investigation. Quote, the search of the vehicle produced a black zipper case containing 4.7 grams of methamphetamine, comma, 0.8 grams of fentanyl, comma, and 6 paper bindles of fentanyl, period.
Okay, so I'm not going to correct the PSI through allocution, Mr. Brown. You and Mr. Mexico are free to explain that or tell me why you think it's different, but it does appear to be coming directly from the police report. Therefore, it's part of the PSI. Any other changes?
No, Your Honor.
The record should also reflect that we received a support letter on behalf of Mr. Mexico. Katie Ford had a chance to review that prior to the hearing today. And then as to the challenge for the scoring, Mr. Brown, you're challenging OB 14, basically the factual sufficiency. Evidence that Mr. Mexico was a leader in a multi-offender situation.
Yes, Your Honor. Just because there were multiple people there does not necessarily make him a leader. The police report, the investigation is borne out in the challenge that it was a Samantha Webster that basically set all this up, was communicating with the CI, is the one who sold the actual substance while Mr. Mexico was currently in, I believe it was in Walmart. Further, Mr. Mexico, even though he has a lengthy criminal history, the only offense that he has for drugs, this is his first methamphetamine offense ever. The only other offense that he has is either possession of marijuana or an offense back in, I believe it was back in July of 2013. And that was a Kalkaska case, I believe, for cocaine or something else. It was a Class D offense. That is the only other, again, besides marijuana, drug conviction that he has. While I'm not super familiar with Ms. Webster's history, I think the fact that this was 10 years ago, he's had any indication with the delivery at all. And this now, given Ms. Webster's role in it at least, is not sufficient to claim that he was a leader in a multi-offender situation.
Thank you, Mr. Rowland.
With all due respect to Mr. Brown, there's a reason the defendant pled to possession with intent to deliver as opposed to delivery. The people agree, as I indicated in paragraph 4 of my response, that Samantha Webster was the one who, and again, she hasn't been convicted yet, so the matter's still ongoing, but is the one who's alleged to have done the first methamphetamine deal. Correct. However, for offense, trying to claim that this defendant and the third male in the vehicle, Mr. Lucan Bell, B-E-L-L, were of no import, quite frankly, we think is belied by the facts. Specifically, as indicated in this particular case and in the police report, but as indicated under my paragraphs 5, the facts specifically are that after Webster disappeared into Walmart, 2 men drove to the front entrance of Walmart to pick her up in the 3-door way. In fact, Miss Webster is the one who indicated when asked about the delivery, said she had to discuss the matter with this before she could provide it. Further, that after a traffic stop was made in the vehicle, the Honda Accord, which this defendant was driving, and Webster in the front seat, Bell in the rear seat, searched the vehicle in a black zipper case located, of course, in the door pocket next to this defendant, not Mr. Webster. Miss Webster contained the fentanyl, which is why it was PWID, possession with intent to deliver, as opposed to delivery, containing the 0.8 grams of fentanyl, 6 paper bindles of fentanyl located in the driver's door pocket, another baggie with cotton fibers, hypodermic nerve bolts, small amount of methamphetamine, and then we had other things found near Mr. Bell's foot. Again, it's a situation where, as set forth by statute, MCL 777.442A requires trial courts to consider the entire criminal transaction, not, in other words, just the delivery that Ms. Webster did when determining the offender's role. What the defendant through counsel refers to, as I said, of being no import, clearly is indicated otherwise by the facts. Again, additionally, people would further submit that the defendant has 3 prior adult controlled substance offenses and also found in his pocket, in addition to some brass knuckles, he had Suboxone strips. So we have effectively, we would submit respectfully to the court 2 leaders in this particular matter as set forth under the offense where there are more or 3 or more individuals. The court can have 2 people be leaders in a multiple offender situation. We think there is more than probable cause for this court to determine based upon the facts, again, specifically indicating that Ms. Webster even had to go and get permission from this defendant to be doing the delivery of methamphetamine. We think there's more than sufficient evidence to find that this defendant was also a leader, maybe not in the original delivery, but clearly in the possession with intent.
All right, so I had a chance to review the law regarding OB 14. As the parties are aware, the court has to find that there are facts by a preponderance of the evidence to support the scoring of a particular variable. I did review the PSI. Mr. Rolla did provide the police report. I had a chance to review all of that information, and that would be the basis for the court's finding here. I agree with Mr. Rolla in terms of the citation of the law that the court can consider the entire criminal transaction when making that determination about leadership under OB 14. And just looking at the standard definition of a leader, it's a person who directs or commands a group of individuals with regard to a particular act or acts. And I think there's a distinction there between a leader of a group and people within that group having varying degrees of participation. And I think what we have here is the latter. And I read through everything very carefully, and the court, under a preponderance standard, the court finds there's not enough evidence to support that Mr. Mexico was a leader. He may have had a different degree of participation than some of the other individuals, but there isn't any indication that he was directing or commanding what was going on. He certainly was participating in it based on the information I read. So the court is going to grant the challenge to OB 14 in order that that be scored at 0 as to both charges. And so that gives us as to count 1, that reduces the total OB score to 15 reduces the level to 2. Gives us a new guideline range of 78 to 130. Is that correct, Mr. Brown?
Yes, sure.
And as to count 2, again, an OB score of 10. This is the level 2. And what is the range of that one?
Look that up.
Guidelines book.
Class is that is a class G.
Class G. That'll be an F2.
And F2 is 5 to, what's this, a habitual? No habitual, so it would be 5 to 23. Okay.
All right, any other challenges to the scoring, Mr. Brown?
No, Your Honor, thank you.
Rolla, do people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Yes, Judge, this is a situation where I don't have to explain to the court the dangers of methamphetamine in our society, especially in our local community here. Now, while I understand and I appreciate the court's ruling on whether or not Mr. Mexico is a leader, that still doesn't change the fact that he was involved in possessing it with intent to deliver, which effectively is still creating the same problem. Because as this court's well aware, methamphetamine is highly addictive, and persons who may have only used it once then become addicted to it, and then sell methamphetamine to enable them to continue their addiction, effectively escalating the numbers over and over and over again in a never-ending cycle. I think under the circumstances, we have a situation where, while I agree it's no longer 84 to 140, it's now up to 130. I still think a MDOC sentence under the guidelines is appropriate if for a circumstance, if for no other reason, that these are 5th and 6th felony offenses, and this defendant is effectively taking part in distributing methamphetamine in our society.
Thank you, Mr. Brown.
Again, Your Honor, methamphetamine, this would be his first conviction for methamphetamine. Candidly, not his first drug conviction, but the first one involving methamphetamine, which is, everybody in here is aware, the legislature has obviously designated that as a more serious drug as far as cocaine or heroin or fentanyl or things like that go. He has had a very troubled upbringing. He does have a history of substance abuse, which I'm sure clouded his memory, clouded his mind. But on top of that, he has also been diagnosed with multiple mental health issues. I think there's some bipolar, schizophrenia, depression, anxiety, PTSD. He's on a variety of medications. I recognize some of them. I definitely know that Seroquel is a very powerful drug used to treat a lot of different mental health illnesses. So he is only 34 years old. He's still got a lot of life ahead of him. He's been to prison on other cases or other convictions, some of which were not drug related at all. I think that he could very highly benefit from some inpatient therapy, some psychological counseling. I would ask the court to try to fashion a sentence that takes those things into consideration to get him the help that he needs. He does have support in the community. So with that, Your Honor, I will leave it to the discretion of the court.
Thank you. Mr. Mexico, is there anything that you wanted to say today?
So I say I take full responsibility for everything I've done for the sentences I'm being sentenced for. I understand the severity that it has on the community. I apologize for my role taking place in that.
Okay, I did read through the report. I'm familiar with what happened in each of these charges. I'm familiar with your background. There's a lot of information about your history and so forth. As you know, your prior convictions raise the guidelines, particularly with regard to the prior record variables. The offense variables in this case, particularly with the court's ruling, this OB 14 are relatively low. So it's your prior history that's really resulting in the higher guidelines in this case. Aside from that, as we've all acknowledged, being involved in distributing and delivery of that substance is something that as a community we have an interest in deterring and punishing to prevent people from engaging in that conduct. Looking at the guidelines in this case, particularly as to count 1, now as scored are 78 to 130. There aren't any real aggravating factors here that I think would call for a sentence at the high end of the guidelines, but there also aren't very many mitigating factors that would call for a sentence at the low end. And so balancing all the factors here, along with what the court recognizes is substance abuse problem on your part, certainly some mental health issues that need some treatment, and when you combine mental health issues and substance abuse, makes it really hard to move forward with your life. And so balancing all of those things together, the court finds that a sentence in the middle of the guidelines is appropriate. It acknowledges your conduct and the wrongfulness of it, but it also acknowledges some of those mitigating factors with regard to your substance abuse and mental health that I just mentioned. So the court is going to sentence you on count 1 to the Michigan Department of Corrections for a period of 108 months to 20 years. You could have credit for 63 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to count 5 or the second charge, 23 months to 4 years in the Michigan Department of Corrections, $68 state cost, those sentences to be served concurrent to each other. You do have the ability to seek an appeal of this sentence, and Mr. Brown is going to provide you with an acknowledgement of his appellate rights.
He has acknowledged that, Your Honor, and I am tendering that to the court.
Mr. Mexico, you are in custody of the state of this. Is Mr. Huffman present?
Yes, Your Honor, he's coming in right now.
Mr. Huffman, if you come up to the podium there, please. And we'll go on the record in People versus Huffman, case number 236599. The record should reflect that Mr. Huffman is present here in the courtroom today.
Larry Brown, on behalf of Mr. Huffman.
This is the date and time set for sentencing. Mr. Huffman, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that? Mr. Brown, are there any additions, deletions, or corrections?
No, Your Honor.
It's misdemeanor, so there are no guidelines scoring. Mr. Rowland, do people have any additions, deletions, or corrections? And do people have any victims that wish to address the court today?
I don't believe so.
One thing I did want to mention, the PSI, your victim's impact statement, indicates that there was one provided to the prosecutor's office. It wasn't attached to the PSI. So if there is one, I would like an opportunity to review that.
Your Honor, I received a the restitution statement. I
Right, that's the only.
I wasn't aware of an impact statement.
I'm just going, the PSI says a victim impact statement was provided and is attached to the report, but it wasn't attached, so. If it's just a statement,
Judge, I can take a look at our other file and I'll give you that.
And seeing how effective it is. Didn't expect this to be as sad as it is.
Judge, actually, there was a victim impact statement, I think it's 2 pages. I didn't see it attached to the PSI.
If you want to email it to me, Mike, I can print it off.
Yeah, I can do that too. Basically, though, just dealing with restitution. And there's a second one in here, and that's what it says that they I can read it. It's 2 sentences, Judge. Let me just read it.
Sure.
For the court. We would like complete payment for the transaction that started this, which included services charged to cover the items that were spent to pursue payment. Please see the attached statement for total amount, and then that was the restitution.
thank you.
I think that's what he's referring to.
Okay,
That's what I can find.
okay. All right, allocution on behalf of the people that Mr. Rowe.
Judge, this is a 1-year misdemeanor. And again, people had some reservations in doing that because Mr. Huffman's got a history of doing this all the way back to 1993. He said this would have been a first felony because previously before he's either had felonies reduced to misdemeanors or completely reduced to payment of restitution. Quite frankly, there's not a whole lot more that I can say. I see there's a recommendation of 12 days jail with credit for time served. Quite frankly, I'm not sure that covers it, even if it's made full restitution, which was the amount of $3,085.44. Thank you.
Mr. Brown.
Your Honor, I would ask the court to adopt the recommendation here. Going through this PSI, and again, I don't know all of what was going through his mind during this period of time. However, all of his prior criminal history was almost 3 decades old. He went 30 years without committing any crimes. So I definitely think this is going to be teaching him a lesson, that, hey, can't do this, and I'm sure it has. I don't know, again, what happened after 30 years that he would do this. However, I would ask the court just to take that into consideration and adopt these recommendations.
Mr. Huffman, anything you want to say?
No, sir, I'm sorry that I did it. I will not do this again. I promise it. It ain't gonna happen. All right, I paid it, I did wrong.
All right, I did read through the report, so I'm familiar with what happened in this case. And Mr. Rolla, just, I mean, for the record, is there any outstanding restitution or has it all been paid?
No, Judge, okay.
All right, so I'm familiar with what happened in this case. There's also information about your prior history and so forth in that PSI, so I've read through all of that. And, there are some factors here that we call aggravating factors, which make it worse, the amount of money involved. The fact that you do have a prior history regardless of the age, which should have been enough of a warning for you not to engage in this kind of conduct again. It does damage a business, a local business, that I'm sure has a hard enough time keeping things going without having to go with these kind of things.
I had spoke,
What's that?
I had spoke with the owners.
Yeah. There are some mitigating factors here that you have paid the restitution back. It's certainly a positive. At least that makes them financially whole in terms of the amount here, although it doesn't make up for everything. And certainly the community in general has an interest, and the court has an interest in deterring this kind of conduct, punishing this kind of conduct when it occurs. The court could sentence you all the way up to a year in jail for this. I don't think that's appropriate. I don't think that kind of penalty. But I do think some jail time is appropriate. However, I don't have a problem having you participate in the work camp program and being released to that immediately. This is a nonviolent crime. The court doesn't have any concerns about public safety here. And I think serving your sentence through the work camp program will provide enough punishment. So the court is going to sentence you to 90 days in jail with credit for 12 days served. I don't have any objections to your immediate release to the work camp program. Serve out the remainder of that
I
time.
turned myself in on Friday. I got a doctor's appointment Friday.
Okay.
And it's in Traverse City and it's a cancer doctor.
Okay.
And they're gonna tell me when I gotta have surgery. And I'll bring all the paperwork to this court.
And you're probably going to be out by today. You're going to go with them right now. And as soon as you get booked in, they're going to screen you for the work camp program and you're probably going to.
Oh, okay, so I'm leaving today. I was under the understanding you were gonna put me in jail for 90 days. Okay.
So, again, if the court doesn't have any objection to immediate release to work camp, court's going to order a crime victims assessment in the amount of $75, attorney fees of $350, court costs of $325, and a $50 state cost. If I didn't say it already, there's 12 days of jail credit here. You do have the ability to seek an appeal of this sentence because it's a misdemeanor. There are no written appellate rights, but if you wanted to file for an appeal, you would need to do that in the next 21 days. If you have questions about that, Mr. Brown will be able to answer any of those questions if you wanted to appeal the sentence. Mr. Rolla, anything further that we should address? Mr. Brown?
No, Your Honor, thank you.
So you're gonna go with these guys right now.
Over to jail.
Our next hearing is set for 3:15, so we'll take a short recess and then we'll come back at that time.
We're on record in People versus Rauschelo, and Mr. Chakowski, if you and your client could come up to the podium, please.
Yes, Your Honor. Thank you, Your Honor.
Case number 246708, and we got Mr. Rolla here on behalf of the people, Mr. Chakowski here on behalf of his client, and this is set for the status conference today. Mr. Chakowski, can you tell me where things are at with this?
Certainly, Your Honor. Mr. Rushlow has recently been charged in Sheboygan. I'd like to have an opportunity to speak to the prosecutor there and also Mr. Rolla here to see if I can't resolve the matters jointly. I did just provide some discovery to Mr. Rolla as well. I think that he appreciate looking at before we have those discussions. So I'd be asking the court for an additional status conference and please the court. Thank you.
Okay, Mr. Rolla, you have an objection to that?
No, Judge. In fact, I also spoke with Ms. Goodrich, who's the prosecutor in Sheboygan County on the 2nd of this month. I was made aware then at the time that Mr. Rushlow also has charges there. In that case, there's CSAM charges. And I was aware that more material might be coming. Should this matter go to trial, I imagine both the prosecutor in Sheboygan and our office would then be filing 404B 609 and MCL 768.27A notices for the proceedings. So no, we have absolutely no objection to adjournment.
Okay, Mr. Rushlow, have you had a chance to talk to Mr. Kukowski about this?
Yes, sir.
Is that how you want to proceed?
Yes, sure.
Okay. Is 30 days going to be enough to do all that, Mr. Kukowski? Do you want to set this out at 60? What I don't want to do is just have you guys continually coming in.
Oh, no,
Have set a date far enough out.
I agree. There was 7 electronic devices taken in a search warrant. I know they at least reviewed the phones. I'm not sure if they've reviewed all the
I don't think all of them. No.
stuff. So maybe 45 days. I
Okay.
think if something comes of that and wants to be used, I certainly want to be aware of that.
Okay.
Thank you, Your Honor.
All right. So I have a mid-June motion day, so I'll set this for a status conference at that time. And we'll go forward from there. Anything further on this file, Mr. Kukowski?
Not from the defense, Your Honor. Thank you.
Mr. Rowland?
No, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Good to see you.
We did have a hearing set for 3:30 in People versus Charles Baker, case number 216087. That was set by Zoom as a motion for resentencing. It's now 3:35. I don't see either Mr. Baker or his attorney, Mr. Siegel. That was adjourned.
We don't have that.
It was adjourned.
Okay, yes.
Okay,
Okay,
so
I'm like,
that was
what?
news to me, because I had somebody else to comment on the record on it.
Can't for a minute.
we'll wait until that gets reset. So as soon as we have Ms. Clark and Ms. Perry up here, we'll proceed further.
So I'd ask the court to consider that with that sentence.
All right, thank you. Ms. Clark, anything that you wanted to say today?
Just wanted to say, like, a lot of the reason that I got kicked out was because of a transportation issue. I was living like 50 minutes away due to a domestic violence issue, and when my car broke down, like, transportation became almost impossible for me. So, and I mean, I guess I really should have tried harder, but I didn't know what to do. So I'm sorry.
I did read through the report. I'm familiar with what's happened since your original sentencing on these charges. And, you know, in the original sentence, the court imposed 10 months in jail that held that in abeyance, give you an opportunity through the drug court program. Obviously, things did not go well as part of that. I'm sure that your transportation issue was part of that, and I can understand there's a reasonable explanation for that. But part of it too was drug screens that weren't coming back clean. Let's put it that way. They were coming back as diluted with levels that didn't make sense. And you know, I never presided over this drug court program, but I did in Kalkaska, and I know how those tests work, and I know that if you're clean, they come back. So I suspect that they came back diluted and otherwise not clean because you weren't clean and taking steps to try and not have that result come out. Based on that, the number of violations that you had during the drug court program, the court finds that it's appropriate to impose that original sentence that the court held in abeyance. So the court is going to impose that sentence of 10 months as to file 216098. You have credit for 48 days served. As to file 226458, you have credit for 47 days served. The court is also going to order that you be discharged unsuccessfully from probation in this case, and then court will preserve any outstanding fines and costs. You do have the ability to appeal the sentence or seek an appeal of the sentence. You can provide Ms. Clark with an acknowledgement of appellate rights. Ms. Clark, these papers are going to explain to you how to appeal the sentence if you want to do that.
That's okay.
Goes to the court.
They still have, yeah.
Clark, you are named in the custody of the county. Very good. Record of People versus Perry. This is case number 226367. Record should reflect Ms. Perry is present here in the courtroom today.
Mr. Chairman, like all the people.
Gary Gill on behalf of Mr.
Today, the time set for sentencing in this matter. Ms. Perry, have you had a chance to go through the pre-sentence report and talk to Mr. Gill about that? Okay. Mr. Gill, are there any additions, deletions, or corrections that need to be made to that report?
No, yeah, thank you.
For the record, I did receive a letter on behalf of Ms. Perry. I did have a chance to review that letter before the hearing today. And in terms of the scoring of the guidelines, Mr. Gill, are there any challenges to the scoring?
No, Judge, thank you.
Mr. Rolla, did the people have any additions, deletions, or corrections?
No, Judge.
people have any challenges to the scoring?
We do not.
Anything on behalf of the people for allocation today?
The only thing I would have indicated as far as elocution, again, we didn't challenge it as the scoring. But just as the court's aware, under now the current holdings in People versus Baskinville, BASKNVILLE, which is at 333 Michigan Appeals 276 page 301, 2020 case, and also citing People versus Sowers, SOURS, 315 Michigan Appeals 346 at pages 341 through 350, a 2016 case. Since the defendant failed to appear for sentencing on April 5th, and a bench warrant was issued, the court could have actually found that she was interfering with the administration of justice. We're not asking for that scoring, but we do ask that the court to take into consideration her, if you will, non-appearance before the court, as well as anything in imposing sentence in this matter. The guidelines are 24 to 40 years, sentencing with 2 days credit within the guidelines.
Thank you, Mr. Kilo.
Well, on behalf of my client, I'd just like, and the court knows, she's spent a significant amount of time in Bay City to take a look at her addiction issues. And she knows she's going to the Department of Corrections, which is going to be a significant amount of time relative to her sobriety. Control. I'd ask the court at this time, I don't know if she's eligible for the 60-day, 9 days credit, but if so, I'd like to see that. Ask the court to consider boot camp or some kind of based on her performance at prison.
All right, thank you. Ms. Perry, anything that you want to say today?
I'm sorry, I didn't hear it.
I did read through the report, familiar with what happened in this case. Obviously, it's been on hold for quite a while. You were absconding. I understand based on the letter that was sent that you may have had some health problems during that period of time that may have contributed to that. I don't have any reason to believe that you didn't have legitimate health problems. However, this is something that needed to be taken care of the right way, along with your health problems. And certainly just absconding was not the way to do that. Looking at the circumstances as a whole and the guidelines, which are 24 to 40 months, the court finds that the sentence within the guidelines is appropriate. I think based on your conduct as well as what's happened during the intervening, I don't know, year now, between when you entered your plea and finally having sentencing, that a sentence within the guidelines, but near the upper third is appropriate to account for your conduct in this case, as well as your conduct since entering the plea. The court is going to grant jail credit 69 days. The court is going to sentence you to 36 months to 20 years in the Michigan Department of Corrections. Again, it's credit for 69 days served. Restitution in the amount of $100 payable to the Otsego County Clerk to be dispersed to Straits Area Narcotics. A DNA testing fee of $60, a state cost of $68, a crime victim's assessment of $130, court costs of $325, and attorney fees of $350. You have the ability to seek an appeal of the sentence. Mr. Gilo is going to give you some paperwork that explains what your appellate rights are. It's not a requested court appointed lawyer to help you with it.
Judge, there was a housekeeping matter. I apologize for bringing it to the court's attention. There was a typographical error actually under evaluation in plan on PSI on page 1, where it indicated on March 3rd, 2023, she were guilty of possession of methamphetamine and was scheduled to be sentenced on April 24th. I don't think it was actually possession. actually was a delivery. Possession only the 10-year offense.
Okay, and that is reflected on the cover page, so the court
Correct, Your Honor.
order that be corrected.
Mr. Judge, you sent her to 36 to 20 years?
36 months.
Okay, 36 months to 20 years.
Correct.
All right, my bad.
Ms. Perry, you are admitted to custody of the state of this next position.
Thank you, Judge.
We're gonna ask Chief for Ms. Clark.
Thank you.
That concludes our docket for today. We're to be in recess until 9 a.m. tomorrow in Crawford County.